Let me bring back our legal analyst here with us. And Jeremy, as you listen to these arguments, it does get a little bit into the legal weeds for an average viewer. But how do you see it in terms of laying out what we are hearing today?
Clearly, what Trump's counsel is trying to do is liken this or tie it back to what we recently saw with Harvey Weinstein, that there's a propensity here. And if you don't instruct that, first of all, if you allow it in, though the judge can, because by its nature, all evidence against an accused is prejudicial. That's the nature of it. But there's a weighing and a balancing. And the argument is that it shouldn't have come in. But if it did come in, there should also have been some sort of limiting instruction, which Judge Kaplan failed to do appropriately. But you can't conflate the two. You can't conflate what happened in criminal court in the state of New York and New York County with the federal case, because as Catherine just said, and as was pointed out here, when you look at the federal rules, you're allowed to introduce that evidence, that prior claims and prior accusations and findings of sexual assault that relate to this same case. Not a propensity, but it can use, for example, again, modus operandi. So the argument that counsel is trying to make for Trump is likely not going to hold the water he wants it to hold, and I'd expect that it's not going to go his way for that reason.
And so you mentioned Harvey Weinstein's case, because I think a lot of people are thinking about that, where his case was just recently overturned, that verdict in that case. Was it also a difference of criminal versus civil? Is that another important distinction here?
Absolutely. There's two big distinctions. One's a state court, one's a federal court. One is criminal and one is civil. So that being said, to be very, very clear, the federal rules allow this specifically. We're not in state court. We're not in criminal court. We have to play in the playground or in the four walls of that courtroom that we're in, and that's federal court.
So Carroll's team has argued, at least in the brief, that Trump engaged in a pattern of abruptly lunging at a woman in a semi-public place, pressing his body against her, kissing her, sexually touching her without consent, and later categorically denying the allegations and declaring that the accuser was too unattractive for him to have assaulted her. And E. Jean Carroll's lawyers argue that the verdict should stand, that it wasn't even close. So, Catherine, could there be an outcome here where the appeals court could say, well, maybe some of this evidence was too prejudicial, but if it's not even close, we're not going to throw out their verdict?
That could be. And it's interesting because if you think of the Access Hollywood tape where he says on the tape, when you're a star, you're allowed to do that. What he said, grab the women by you know what. And that's what he was found liable for doing to Miss Carroll, and that's what those two other women said. So there's that overwhelming evidence of liability. I'm using liability because, again, this is civil, this is not criminal. Criminal, it is very different because a person will lose their liberty, and so the courts are very different, whereas civil, it's a loss of money, which is a big deal, but it's not a loss of liberty. And as Jeremy said, there are specific rules of evidence in the federal court that actually allow this evidence, as long as it's not too prejudicial, and Judge Kaplan has determined that it wasn't prejudicial. Let's see if the Second Circuit Court of Appeals agrees.
Jeremy, you're a defense attorney currently, so do you see any strong argument to be made for Trump?
Well, you absolutely have to make this argument. I mean, whether it's going to be successful or not, and strong is a relative term, you have to go with whatever you have, and you work with that. And the argument being that if you precluded or did not allow these two other women to come in about this old story of allegations that he did these things to her, then, well, you know what? That could have turned the tide. If I was allowed to, as the accused, as the defendant, to cross-examine fully E. Jean Carroll, then this would not have happened. This is reversible error. It's not just harmless. This is reversible error. And reversible error, by the way, people should understand, does not mean the appellate court says, okay, you win, case closed, it's over. It sends it back down to the trial court to start this all over again, potentially. So you have to go with what you have, and that's the best that he has right now, which is propensity on the heels of Weinstein. And, there's people who will support Trump no matter what, and that's also a public forum for him as well.